So I was lucky enough to study family law in my undergraduate law degree, and I really enjoyed it. I think family law is special because every case you're dealing with, people dealing with a really difficult time in their lives. It's always really interesting because it's people's personal lives and their personal issues. I personally find that more interesting than company or other areas. It's a bit more drama in family law, which I quite enjoy. So after I did that at university, I sort of knew I wanted to do family law, which is why I pursued it. But that was my entryway into it.
Yeah, my name's Grant, as you know. Firstly, to say thank you for all coming this afternoon. My background is actually commercial initially. So I worked in a lot of commercial, so it's American Express, some of the consultancy companies like Accenture, and then I was negotiating a lot of the commercial contracts, and that's when I got my interest in law. So I was thinking, why am I negotiating with all the barristers and solicitors when in fact, actually I'd like to get into law. So I naturally went to law thinking that I would go into commercial side, and certainly my children, my wife would have loved me to go on the commercial side, but I didn't. So initially I started going into a mixed set, where I went in doing civil, criminal and family. And like Cara, I sort of naturally went into family because one of the things I'm very passionate about, certainly from a family point of view, is all about the children. So whatever happens, whatever the drama is, whatever the difficulty is, it's about the paramount interest is the children. So it's all about focus. So whether mum and dad hate each other, whether they're divorced, whether there's lots of things, it's about what's right for the children. So that's where I've come from. And just to let you know the areas where I do some financial remedies, I do what we call private law, I do direct access, so when obviously anyone comes directly to me, and I do a lot of public law, which is, I call it the horrible stuff. So it's whether it's non-accidental injuries, whether it's abuse, whether it's domestic abuse, whether it's sexual abuse, and doing all those type of cases. But whatever you do, it's all about, interest in the children.
So you touched on the types of cases that you work on. Could you give some insight into what areas that you kind of enjoy to the room?
Yeah, of course. So my chambers, we don't do any of what Grant says is the horrible stuff. So we don't do any public children law. We're quite specialist in that we mainly do financial remedies. So how are the assets divided when a couple divorces? And even within that, there are many issues that can arise, which I really like about financial remedies. So there can be business assets involved, trust assets involved, leading you to sort of dip into those areas that you may not have the opportunity to do otherwise. We do a little bit of private children law, which Grant mentioned, which is more dealing with who the child should live with when a couple separates, whether they should spend time with the other parent, how much time. Sometimes there's safeguarding issues that are involved. Does the parent have a drug or an alcohol problem, or are there domestic abuse allegations that need to be dealt with? So my chambers only does those two areas. And in terms of the benefits of those areas for me, as I say, with financial remedies, it can get quite forensic sometimes, dealing with these different types of assets. Sometimes you're pouring through someone's bank statements, trying to spot if they have an income stream they haven't disclosed. It can be quite forensic in that way and analytical, which I really enjoy. And with private children law, as Grant says, it's all about the children in every area of family law, but obviously very particularly in children law cases. And in terms of private children law, what I really enjoy is potentially when those safeguarding issues arise, you have different hearings where there's a lot of cross-examination, trying to get to the root of what happened factually in terms of certain allegations, which can be very interesting. So if you're somebody who's thinking maybe crime would be something you're interested in, a lot of that sort of thing arises in family as well, and they can be quite similar in that way sometimes. So it's a good area to look at if you think that you might be interested in that sort of thing.
And as 3P, we actually do all the areas. So we do the financial remedies, we do the direct access, we do the private law, and we do public law. And just to give you examples of the public law, which I know Cara doesn't do. So, for example, your child comes to school, it's got a bruise, and says, "Oh, Dad hit me," and then gets taken to hospital. The medic asks the child about, "Okay, what your leg hurts? Let's do an X-ray, finds he's got a broken leg. How did it happen? Oh, I tripped over at home. Parents come in, and then they say, oh, yeah, tripped over at home. And the medic is saying, doesn't quite feel right. I don't believe that injury is caused by tripping over. And so all of a sudden it kicks off. So then there's a child protection medical. The medical looks at, we think it's a non-accidental injury. So that's the medical opinion initially. So initial view from that child is a non-accidental injury. Then all of a sudden, the local authority get involved, proceedings start, come straight to court. This child has got a broken leg. They think it's a non-accidental injury. Might be mum, might be dad, might be grandma, depends who had the child recently. And then the local authority potentially said, right, we want the child removed. So the child gets removed, they go to court, there's a big fight, the child gets removed, gets put in foster care. And then behind the scenes what happens is then we then get experts, we get all the medical experts come along, and they do a review, we get radiologists, depends what the injuries have got, it could be neuroscientists. You get all the medical, you get a statement from mum, dad, grandma, whoever's had that child, might be nursery, and you're trying to work out how that injury happened, when it happened, and then you've got to try and work out in the court process about who did it. So that's when you forensically look at all the medical reports, you get involved from a barrister point of view. So if I'm representing mum, so she's in what we call the pool of perpetrators. So I'm representing what she's saying, I didn't do it, it wasn't me. So she's saying it's dad, is she saying it's grandma, or is she saying I don't know? So then you go through a whole forensic analysis, which is called fact find, where you get mum gives evidence, father gives evidence, grandma gives evidence, all the medics give evidence, social worker gives evidence potentially, and then the judge has to make a decision, looking at all that evidence, of who caused that injury. How was the injury caused? Who caused that injury? Was it mum? Was it dad? Could it have been all of them, or I can't decide? And then at the end of that, that really determines what happens with that child. So if mum said, actually, it's not mum, I know it's dad, then they say, okay, dad moves out, child go back to mum. And so that's how the whole process works from a fact-find point of view. Sorry, one question from.
I'm quite interested. So you do prosecution, so or we represent the clients to defend, for example, mum, as in your example.
So the question was, do you do prosecution or do you only represent the client? So a lot of barristers, they can represent the local authority, which is, I think your word's prosecution. I've done some of that in the past. I don't do that anymore. I represent primarily the children or the child and of the parents. Some parents
The child needs to be represented as well.
Yes, so you've got representative of the local authority, who are in your way the prosecutors. You've got representative of mum, dad, grandma, whoever's in that, and then you've got representative of the child. And the child's represented by a guardian and also by a solicitor and a barrister, because the good thing that about we talked about in the family law, whatever happens, whatever complexity, the court says what's in the interest of the child. That's the focus, that's the judge's focus, what's the interest of the child. So from your point of view, you're saying mum and dad hate each other, they're divorced, dad's had an affair, mum said, well, you can't see the children because you've had an affair, so I'm going to keep the children, you've got no right to see the children, which is actually irrelevant because it's about the children. The children have a right to see mum and dad. So just because you've had an affair doesn't mean you shouldn't see the children. It might be wrong, morally, it might cause trauma for the children and trauma for the wife, but it doesn't mean you shouldn't see the children. Sorry, another question here.
Provided this doesn't take you too far off track. With child witnesses, I guess you'd also be using intermediaries a bit, do you?
You do. You use intermediaries, say, for instance, is it cognitive issues? So parents might have cognitive issues, might have low IQ, and they need support, and they need intermediaries to be in court. And the intermediary, just to let you know, is there to assist the layperson, to explain to them what's going on, to support them in the court proceedings. Because if you're a counsel up front, you're standing there, you're talking to the judge, someone needs to be behind with your client to explain this is what's happening, does need a break, how they give evidence, and also the child. The child, depending on the age of the child might be called to give evidence.
And then the other piece around it was just, and sorry, this is really off-piece, but I think in the real world it exists, is how do you know that the child isn't being manipulated into taking a side or whatever? I mean, you can't really ultimately know, but how does one attempt to manage that?
So the question is, how do you know whether the child has been manipulated?
Yeah.
So as an example could be, we call it parental alienation. So if mother is particularly upset about father because he's had this affair, you're not going to see the children. And so mum starts saying to the child, dad's horrible, he's seeing this other woman, doesn't care about you anymore. So he's manipulating the children, trying to alienate those children from the father. So that's where you get potentially a guardian involved who talks to the children, understands it. You might get experts on parental alienation who talk to mum, who talk to father. And part of it is if contact is happening, whether mum's supporting contact, whether she's not supporting contact, you know, all of a sudden the child won't get out of the car. It's a simple question, but a very complex answer, as you can imagine, because you're dealing with a lot of manipulations happening behind the scenes that you don't know what's going on. You don't know what's been said by, it doesn't have to be mum, my father, could be, you don't know what's been said to the children, so you don't know, and you've got to try and get to the bottom of that. But parental alienation is a real thing. You know, it might be purposely done, it might be unconsciously done because that partner's hurt. But it's a very good question. Sorry, can I take a question from the front and I'll take a couple from the back? Yeah, sorry.
Thank you so much for your introductions
That's
so
right.
far. Something that gets brought up a lot within family law is having empathy. Are there any other traits that either of you, both in your respective areas of law, I know you practice more in financial remedies, and you more perhaps with child law, any other traits that you would say makes for a successful family barrister?
I think this is potentially linked to being empathetic, as you have said, but I think interpersonal skills are really important. And what I mean by that is the ability to put someone quickly at ease and get them on side is really important in family law. Particularly, I'm very junior, I'm only in my second year of tenancy. A lot of the time I go to court, I've not met my client before, the judge is potentially determining obviously something very consequential for them, and you don't have a lot of time to ensure that you build up the trust with that client, that they'll accept your advice, especially if your advice is you're not going to get exactly what you want, rather this is what's more likely to happen. So being able to be warm, friendly, and having those people skills to get someone to trust you quickly, I think in family law is particularly important as compared to other areas. And I think that goes for financial remedies, children work as well.
Can I also say, I think one of the skills you need, and some barristers take very different approaches. I think my style is to be very straightforward with my clients and to be upfront with them saying, look, today your child's going to be removed. I'm going to fight for your cause. I'm going to fight as hard as I can, but I'm telling you now, your child's been removed. In the instance that say your child's got broken bone, they think it's you, they're not going to allow your child to be in your care today. But we're going to fight that through and we're going to try and get the child back into your care. Some counsel don't take that approach. They keep the expectations high and then leave it to the judge and say, well, the judge made a decision. That's not my style, it's a personal style. I prefer to be straightforward with the client. The client may not like it, may not like your advice and may not like your views initially, but as long as they see you fight for the cause, but behind the scenes, when you're having that privileged conversation with the client, I think my style is to be straight with them so they know where they are. That's all. Sorry, another question at the back.
Have there been instances where, say, in a case, the verdict of the court might solely rely on the testimony of the child, but the child may have been seen as unfit to give a testimony due to maybe tampering or trauma or disability, etc.?
Let me try, and I didn't hear all of it, but I think my understanding of your question is, have there been cases where the testimony of the child has been given, but there's issues about the testimony of that child? Is that a fair summary?
If the verdict of the court would be reached upon giving the testimony of the child, yes.
Yeah. And I think there's some very strict rules about how a child gives testimony, whether they give evidence at all, because depending on their age, there's a thing called a re-W analysis, so the guardian will look at the child, consider the child, look at the emotional harm potentially of the child. It might be they get asked questions outside of court by an expert, and then all that is written down and that becomes part of the evidence. It might be they give evidence in court, but from the court's point of view, it's the judge's role, and you'll hear the saying, look at the overall canvas. So when you see a picture behind me, you look at the whole picture. So part of that picture might be what the child's talking about. Part of that picture might be what mum said. Part of the picture, what the expert says. So the judge's role is to look at that overall canvas and then actually weigh out all that evidence. And also importantly, determine what weight they put on the evidence. So one of the witnesses might be just not credible. You know, they've caught out in evidence, caught out in cross-examination, they've changed their view several times, they've contradicted what they've written in their statement, and actually just says, your evidence is not credible. Therefore, I'm not going to consider your evidence as part of my overall view. And that's where the child's point of view, because the child's very important, because obviously right from when the child makes an allegation, so it says, dad's hit me or dad's abused me, how that was said, who is it said to, what type of questions were asked that child, was it a leading question? Because the issue you've got is, you know, oh, tell me about dad that hit you. So if you're reinforcing that and you're not being an open question, you're going to get criticised. And also, is mum then reinforcing it behind the scenes? Oh, dad hits you, oh, dad hits you, dad hits you, dad hits you. So the child then becomes even more convinced that dad's hit you, but actually it may not have happened. So that's what the judge has got to look at. A lot of time the judge's, you know, decision can be easy. Times like that, the judge's position is very, very difficult. I hope that helps. Any other questions? One right at the back.
I was curious about within a fact-finding hearing, as if it has a criminal element, how do you ensure a fair trial? And then as a secondary part, if it then, as family court generally is meant to stick to their 6-month timeline, and criminal court often goes beyond that, if they're then found not guilty in the criminal court, say of domestic abuse or a non-accidental injury to like a child abuse, does that then reopen the child's case in child protection?
So I think my understanding of that question is you've got the family procedure, the court, and also behind the scenes you've got the issue of potential criminal trial and effectively how they interlink. So my view of that is in family law, if there's potential criminal proceedings, so non-accidental injuries, then there may be a warning from the court to saying whatever you say, even though family proceedings are private, potentially your statements, your witnesses, the judgment then could be transferred into the criminal court. And what happens is exactly what the police do. So they make an application, they make a formal application, they're represented, and they ask for, I want to see all your expert reports, I want to see all your statements, and they make an application to the family court. So even though the family court goes through that process and makes a decision, as you know, the family court is about balanced probabilities, so they've got to find, well, there's non-accidental injury above 50%, whereas criminal court, you've got to be beyond reasonable doubt. So obviously the standard of proof is very different. But the police want that information. They want the judgment, and they can make an application to get that. So from the client's point of view, you've got to be very clear that that can happen, and it does happen. So the court may say, yes, there's no findings, and then the criminal proceedings carries on behind the scenes. That might take another 6 months, a year, and then they may be found criminally. So it does happen, it happens all the time. The police are there. Obviously their standard proof is a lot higher, but they want that information.
Sorry to interrupt, we've got about 9 more minutes.
Sorry.
So we've got time for about 3 more questions. So we'll have you.
Let's say that you initially think that the case is going to be decided in favour of the client to make a favourable outcome, but a surprise happens during the trial, and then perhaps at the end the judge makes a decision that is unfavourable, and your client becomes hostile. How do you deal with that situation?
I think you say, so the question was, if you've advised your client that the trial is going to go a certain way and something comes up in the middle of that trial which changes what the outcome is going to be, and then they're let down at the end, I think that your duty to keep your client well advised obviously continues throughout the trial. So as soon as that unfortunate thing happens that you think will change the outcome, you want to have a discussion with your client and advise them how that's going to impact on the judge's decision. So what you don't want, I completely agree with what Grant said earlier in terms of you want to be straightforward with your clients. You want to advise them of what the likely outcome is going to be as soon as possible and keep them advised about that. I don't think you're doing your job properly if your client is surprised at the end of the trial as to how it went. You want to keep them as much as you can expecting the likely outcome. So yeah, if that changes, update your advice to your client. And yeah, it would be unfortunate if that happens, but it does happen sometimes, and you just have to keep managing their expectations throughout.
Can I just add on that? I think managing expectations is an important point, because I think what you were saying there is I may not be able to tell you what's going to happen at the beginning because we haven't had all the evidence yet. And often it's quite a classic saying, certainly within the council, where you've got a really strong case until your client gives evidence. And so you think, oh, it's all in my favour, all in my favour, all in my favour. Your client gives evidence, gets cross-examined, and then contradicting what he said before, and then your whole case just collapses. So you're right. I think it's a very good warning, actually, to be careful about what you say, being too definitive about your advice until you've got further on down the evidence line. Sorry, one more time.
Yeah. So in the context where you're dealing with really vulnerable individuals,
yeah.
the outcomes, whether sort of you win or lose, can often be sort of quite difficult to kind of cope with, can have a really dramatic impact on these people's lives. Were you, in terms of your personal resilience and your sort of psychological investment in this, were you ready for what you saw and sort of coping strategies? How do you deal with that particular aspect of family law?
That's a really good question, and I don't know if you agree, Grant, but because I'm more junior, I think definitely the start it is really difficult. But it sounds quite bad potentially, but the more cases you do, the less it impacts you. So it is just give it time. I think at the start of my first year of tenancy, I would get really upset if cases didn't go good. It didn't go well for my client. Obviously, that really impacts them. The more cases you do, sometimes it just doesn't go your way. You don't have the best side of the case in whatever situation it is. It happens, and as that just becomes more normalised for you, you get less impacted by it, I think. But I'm not dealing with the really horrible stuff, as Grant said earlier, so I'm not sure how you deal with it.
It's a really good question, because I think it's about, so basically, how do you deal with things emotionally? Mm-hmm. And that question has been asked, certainly outside there at the stands, a lot to me today, because it's so emotional, how you effectively have empathy, you talked about at the front, but also how you also step away from that. And I think you all need to have your own escape route of that. So whether it's running, whether it's computer games, whether it's music, playing music, whatever you want to do, you need to take your way out of it. Because I know with my children said, Dad, you don't work in the real world. I do work in the real world, but thankfully it's not the norm. So you have to try and step away from that and thinking, this isn't the normal world I work in. But as an example, another one I've got, which is an international abduction one. We're from Australia, where Mum brought over the children without Dad knowing. She brought them over here. And you think, oh, make an application, bring them back. He made an application, took time. She then appealed it, went to Court of Appeal, took a long time. They've become settled. They're not going back. And so it's really difficult from the father's point of view, thinking, you've taken my children.
Stolen them.
You've stolen them. So legally, actually, it should be quite straightforward, because it's, again, on looking at the focus of the children, because they're now settled, they're in school, they're emotional, there's more family from Mum's family over here, they've got grandparents, aunts, uncles, they're all invested. It makes it a lot more complicated. But from father's point of view, it's completely wrong. So you've got the intellectual damage, you've got the emotional part of it, and how you obviously set your expectations for your client, because it's very complex. So it's not always straightforward. But it's a really interesting question, because that comes up a lot about how you deal with that. And I think that's, when you're looking at family law, you've got to be empathetic, you've got to understand, but also you've got to be able to step back. Some are very aloof, don't really care, and I shouldn't really say that, but actually that's very few, to be fair, very few barristers like that, because most people do care, but it's just being able to step away from that, because otherwise you won't be able to do it very long, because you're too much weight on your shoulders.
But like being a surgeon, I suppose.
Sorry?
But like being a surgeon.
Like being a surgeon, yeah, exactly. Yeah, surgeon doing an amazing job, but if you come too much because someone's died, and the classic is you can't win every case, and some cases are not, I should say, not winnable. When you look at some of the reasons why people are acting like that, when you look at their history, when they've had a psychological assessment, when they've given their statements, and you look at their background, how they were treated by their parents or abused by grandparents, whatever it is, you then understand in context why they are what they're like, whether they've got vulnerabilities, whether they've got cognitive issues, and they've been taken advantage of, whether they've domestic abuse, because the history is like that. It's how their mum was brought up. It all explains it. And trying to break that cycle without professional input and support is very, very difficult. Might be easier for us because potentially intellectually you can break it down intellectually, but when you're a vulnerable with very difficult background, that breaking it down is very difficult. And you all of a sudden it makes sense. You see why they're in that situation. So I'm rambling a bit, sorry.
Okay, we've got time for one final question.
This is like obviously quite a personal question to everyone if they're answering it, but for you, if you came up to the application question of why family law, what answer would you give to that?
The answer I would give is that it's all about people. Every case is about difficulties in people's personal lives. There's a lot of court work. You're in court a lot, so you're always meeting new people, your clients, developing good relationships with them. Because it's so people-oriented, I just find that so much more interesting than any other area. I wouldn't be interested in any other area of law, to be perfectly honest with you. Personally, that's what really appeals to me about family law.
I support all those views. I think it's the whole mix. You've got the advocacy, you've got the people skills, you've got the financial, you've got advice writing, you've got the skeleton arguments to do, but also you've got the interest. Almost every day is very different. From being in court, standing in Court of Appeal, to doing a magistrate's court, representing a client, to representing a child, to all of a sudden things happen last minute and a video arrives and so there you go, it completely changes the whole case. I think there's a lot of variety there. On the flip side of that, it can be quite difficult from a stability point of view. If you're a planner and you want to plan everything to minute and you schedule everything, that can be quite difficult. And I'll give you an example. So this week I had a 6-day trial, 5 days starting on Monday. The judge says on Friday evening, I can't sit Monday to Wednesday now. And all of a sudden you've got 3 days out of your diary, and then it's Thursday, Friday, then it goes to the next week, so then it upsets all your next week, all your cases next week, and it messes the whole thing up. So all of a sudden you've gone from I'm planning, sorted, all of a sudden it's up in the air and it's changed. So it can change. It obviously can change any area of law, but particularly in family, because things settle. So you're due to have a final hearing. It's settled just before you walk in, or the day before. So it comes out of your diary, and things happen a lot. All right.
Fortunately, that is our time, but can we give a round of applause to Cara?